Hi, Ben. Can you hear me? All good? Cool. It's good to be able to debate you again. My favorite debate I've had on this site was with you, so good to be able to do it again. Now, let me get right into this. First, let me clarify that I absolutely believe there should be laws restricting elders from grooming minors for sex. Further, any sexual relationship with a prepubescent child is abuse and should be legally prevented. But putting that aside, we're going to be discussing those who are of sexual maturity, but perhaps not yet of mental maturity. So the only actual purpose of age of consent laws is to prevent sexual grooming. So the standard we should set is that laws governing sexual consent should be effective in stopping sexual grooming while still being fair to the two participants. Now, this leads to the two harms I see in the current system. The first is that age of consent laws are counterproductive. When a government names a specific age where a person is sexually available, it refocuses the mindset of potential suitors who no longer have to worry about the maturity of their target, but can instead simply focus on age. For instance, I can't tell you how many times I've heard, "She's 18 now, bro, just go ahead and smash, go for it." But those same exact people would say that any type of sexual activity at age 17 and a half is horrible. But for those people, it has stopped being about the person and their maturity, and it is instead now focused on the number that codifies them as available. Girls, and some boys, but mostly girls, literally go from protected at age 17 to a sexual target overnight, even though nothing in their biology has changed. Sexual grooming still occurs, which means that the law is ineffective and counterproductive. The second harm that I see is that age of consent laws are arbitrary and unfair. There is no biological difference between a 17-year-old and an 18-year-old. In fact, there's very little difference biologically between a 15-year-old and a 25-year-old. There may be a mental difference, but scientifically, there's very little actual change. So slapping the number at 18 is arbitrary and unfair. Because of these harms, I propose the following solution. Laws regarding sexual maturity should be based on the following characteristics. Number one, the capacity of the individual to consent. If a 50-year-old is grooming an 18-year-old who is not mentally mature enough to consent, this would now be prevented. But if a 20-year-old is in a relationship with his 17-year-old girlfriend, this could be acceptable. It should be dependent on the capacity of the individual to consent. Two, the question of who initiated and primarily drove the relationship. If the minor primarily drove the relationship, they were not being groomed, so it is not a problem. Three, the difference in age between the two partners. Not just age, but the difference in age. And lastly, the last thing we consider is the age itself.
Alrighty. Okay, so I just want to also cheers for bumping this back an hour and everything, and also excellent to debate you again. Okay, so I just have a few things I want to clear up. The first thing is that when you're talking about capacity to consent, how do you test that? So for example, right, like you're talking about, well, look, we should be about prepubescent. That's a problem, but obviously pubescency correlates with age pretty reliably, right? As in all of the people who are prepubescent are young, and all the people who are post-pubescent are older. And particularly that you said your problem was that, guys are targeting, for example, people who are over 18. Well, there aren't going to be any over 18-year-olds who are prepubescent, right? So they're still going to be targeted. And in fact, I think if that's the problem, then you're actually just refocusing in a really bad way, because now to be like, dude, she's got tits, she's not prepubescent anymore. So that targeting is still going to happen, but is actually probably going to be targeted at people who are like even more people who share the characteristics which you think ought to be defended. So that's my first question with where is the burden of proof? Because one of the big plus points, for example, for having just a flat age limit is that it means that those who are under 18, for example, who don't say have other responsibilities to protect themselves, are protected by the law in a unique way, which is they don't have to go to court and say, listen, here is my legal argument as to say that I didn't have the capacity, and here's my legal argument to prove that they initiated the relationship. And it's not true, by the way, that all grooming relationships necessarily are, seem primarily forwarded by the groomer. For example, I forget what the guy's name was, but there's a lot of YouTubers who fangirls, go after, and they get groomed. And for all intents and purposes, it looks like they are the one driving the relationship, but it's obviously still a grooming relationship and should be treated as such. I just have those questions in terms of clarifying how the legal system would work, because one of the reasons age is really good, in my opinion, is that it puts the burden of proof away from those who we wouldn't want to have to make legal arguments, considering that they're often under the age of 18 and we wouldn't involve them with other responsibilities. So the other thing I was wondering is, does this logic, for example, apply for you towards, for example, the drinking age, or the age which you're allowed to work and seek employment, or the age, for example, you're allowed to enlist in the army, or the age you're allowed to vote? Right? Because like the main criticism of age limits is people like, oh, they're not exact, right? Like, you know, there are going to be some people either way. And I agree, right? They aren't exact. But the reason you need to draw the line somewhere is that, like, you know, the moment you say, well, the age line doesn't matter anymore, does that mean that you have a bunch of 15-year-olds who go, look, I'm actually quite clever, I deserve the right to vote? Or, you know, 14-year-olds who goes, look, I'm pretty strong, why can't I enlist in the army? So I'm curious to know, would you allow people under the age of 18 to do all of those things? And if not, why not? Yeah, I'll pass it back to you.
Okay. So first you talked about how do we test the capacity to consent. I have two answers to that. The first is that there's a mental versus biological. Biologically, a person who has reached puberty is already considered sexually mature. In fact, in the for the vast majority of civilization, that was considered adulthood. The only question is their mental status. So if a person is mentally able to have a conclusive answer on a subject, then they can be considered mentally able to consent. Now, if that person says, you know what, I was being abused, or someone was trying to abuse me, or if family members of them say, look, that person is being abused, in the same way that our current abuse system or domestic abuse works, that would be the standard. And if that is the case, the burden of proof would be on the others. Because the same standard of burden of proof would rest as with current domestic abuse cases. The second answer I have is you had mentioned prepubescence. Now, the difference between what I'm saying and prepubescence is, I agree that any sexual relationships with a prepubescent person are automatically off limits. That is necessarily false, and that person cannot logically consent. So that is off limits entirely. We are talking about people who have already reached sexual maturity and the question of whether or not they have mental maturity to be able to consent. If they have that mental capacity, they should be able to do so. That is my stance. You talked about the burden of proof. The burden of proof would be the necessary defense would rest with the people who feel they are being abused, or the others who bring the case of believing that the person is being abused. So it would be that same sort of system. You pointed out that not all grooming starts with the person primarily starting it. Like if a 15-year-old was hitting on a YouTuber, your point under this was you actually said, quote, it's obviously still a grooming situation. And how would you be able to tell that? Well, the answer is you can see it from the other things that are happening. The YouTuber is clearly pushing it. They're clearly manipulating. They're clearly abusing. Those factors would still be able to be brought up in a court of law, the same as you could bring it up currently. It's simply no longer based on just age. It's based on the factors of the individual case itself. So even you agree that it would be obvious. You can tell it by the factors there. And then you asked if it applies to voting. Well, that's a different standard entirely. When someone is under the age of 18, they already have the right to have sex. When someone reaches the age of 18, the whole point is they get new privileges. But the age of consent laws are different because it's actually giving new privileges to others who now have the right to have sex with you. So it's a different standard entirely.
Okay. So the first thing I want to clarify very quickly is that when you say you want it to be the same standard as domestic abuse, just to be very clear, it is your stance then that if a 15-year-old feels abused, it is on them to prove in a court of law beyond reasonable doubt that they were abused, and they have to make legal cases to satisfy their arguments. I just want to clarify that, so I'll pass it back quickly. Is that what you stand for?
If a person is being groomed, then yes, that would be on them. If a person has already been groomed, well, then that has already been proven. That's just a question of the individual case itself.
Okay, so here's the problem then. It's giving someone the right to consent also gives them like the obligation to have the capacity to defend themselves in the court of law. And I think that is an incredibly unfair thing to put on people who are under 18. These are people who like almost by other laws, for example, the ability to work, don't have income. So they're purely dependent on their parents. Many of these kids, for example, vulnerable kids who get groomed might not have particularly supportive parents who have those financial means. They have to have, for example, legal knowledge. They haven't even been taught in school yet. They have to be like, they're being, they're having the burdens of a legal system they don't have the right to vote on being applied to them. To me, this seems incredibly suspect, right? That you're now saying that someone who is now post-pubescent biologically of, subjective mental capacity now has the burden of proof put on them to prove beyond reasonable doubt that they were being groomed, right? They have to get a lawyer, that to me seems wrong. And the reason is, right, is that the age of consent laws are not just there for them, but they're also there for the people who have responsibility for them. So parents, right? And the reason this is important is that when parents send their kids to school, or they send them, for example, a psychologist, or they send them to literally any venue in which they are entrusting the care of their child, a person who's very important to them, in another adult's in supervision, it's a comforting thing to know that no matter what, right, if something was to happen, I actually don't need to prove much at all because my child is under 18 and they are protected by the law. I don't have to hire a fancy lawyer. I don't have to prove according to these standards I don't understand particularly well. I know that everyone else in society knows that my kid is out of bounds. And that is a strong deterrent towards people who would, for example, maybe, want to groom a little bit, as long as they, and it's fairly easy. For example, beyond reasonable doubt is a very high test. If I was someone who was grooming and I knew the tests were things like their mental capacity, or I knew their tests were things like who initiated it, then it would be quite easy for a pedophile to, for example, make the conversation seem like there is reasonable doubt as to who initiated. Make the content of the conversation seem like, oh yeah, they're of sound mental capacity, so you can ask certain questions. So the point here is that what parents will start to do is that they will cease feeling comfortable sending their kids to schools with young teachers or sending their kids to psychologists if they need them, because they're afraid that, maybe this actually will lead the risk that my child could be abused, and I'll have to defend in court beyond reasonable doubt against this wealthier person, right? Do you see what I mean here? So it reduces a lot of public confidence, whereas a strict age limit doesn't do that. It deters pedophiles from trying it, and it makes parents feel comfortable participating in public institutions, which are quite important.
Just so you know, your mic has turned off, and your audio was coming through at the end. So I heard the majority of your stuff, but your visual is gone. That being said, from what you said, you talked about how your main problem is that a child who is being groomed would have the burden of proof put on them, which would encourage pedophilia, which, first of all, we have to point out that pedophilia is different than having sex with someone who is sexually mature. Pedophilia is when you have sex with a prepubescent person. It's a very different thing. We're talking about having sex with someone who has already reached puberty, which is not pedophilia. That's very different. Now, I have 3 responses to your overall point. The first is that of personal choice. Once a person is sexually mature and is able to make decisions, it is then about their mental capacity. If their mental capacity is there, they should have the personal choice to be able to do as they wish with their body, which could include having sex with someone who is older. It also could include having sex with someone who is younger. That it is not something that there's any reason to say they cannot make this decision unless they are being mentally manipulated. If that is happening, that is a problem, and that's when you would want the law to reflect that. I am simply saying they should have the right to make the choices that they have with their body, which is sexually mature, as we have already discussed. The only question is mental capacity. The second response I have is that of arbitrary. You even agreed that the numbers are just it's sort of helpful. It's sort of a helpful guideline, even though it's not actually correct. I think we both would agree that there is no biological difference between a 16-year-old and an 18-year-old in terms of sexual reproductive capacity. In fact, the Merck Manual for Pediatrics says that among females, the average female has already reached full sexual maturity at age 16, not age 18. So 18 is a random number in the first place. It is not even accurate. The third response I have is that age is still a factor. I think that you're saying that my case is that we're going to let people get away with it, whatever happens. No. And that people would be able to modify how they write their messages to get through with that. But that's not the case at all. Because anyone who is older, who is going after someone who is younger, would automatically be one of the checkpoints would already be there. Because one of the, I talked about how age is a factor that should be incorporated. I think it is. It's just the overall perspective should not be, oh, they're 18, they're fuckable. Not at all. It should be, they're 18, maybe they're not ready yet, maybe they are. You determine it based on the individual and their ability. Age is part of it, but age is not all of it.
Okay, quick test. Can you hear me now? Yeah, can you thumbs up if you can hear me? Test. Kind of. Oh, shit. Hang on. I actually don't know what's going on. Is it just a loudness thing or is it cutting in and out? Up for loudness, this for cutting in and out. I can't hear me at all. One moment. What I'm going to try and do is I'm just trying to bring it up on my phone. Maybe this will be better. Call out. You can't see me, but you can hear me? Oh, okay, that's all right. I don't mind if you can't see me. Okay, so look, here's the problem, is that firstly, if an age difference is an automatic checkpoint, right, and you're concerned about people over 18, then you're actually restricting the liberties of everyone. Because now, even people who are adults, who are consenting adults, for example, what's the Playboy guy's name who has the really young wife? That, for example, that marriage would now be pretty much viewed as an automatic checkpoint that it's abusive. So you're actually restricting, and many men, for example, marry quite younger women, like decades younger, for example. So is that going to be liable to be taken to court whenever, for example, that marriage breaks down? That seems wrong. And I think you've missed the point of the court of law. It's the reason which you would draw the line at 18 is it protects people who are under 18, who don't have financial capacity yet, who don't have, for example, the ability to the legal knowledge, and don't have they're rather dependent on their parents. It restricts their ability from having to defend themselves in the court of law if they are abused. Because your model, your idea says that a 15-year-old who has sex with like a 19-year-old or something has to prove in court beyond reasonable doubt, right, that they were actually abused. Like, that's crazy. Where are they going to get the money? Where are they going to get the legal knowledge? It's easy to get away with things because the standard for the law is so high. So the reason that age is there is to protect people who we don't even allow to work yet properly in many cases, or we don't allow to vote or enlist in the army, to stop those people from having that responsibility. So that's why it's there. It's also the parents' confidence stuff you didn't really address very much. The other thing as well, which I wanted to bring up, oh shit, what was it? Hang on one moment. Right, okay, hang on. With the age is not a perfect indicator. Like, you yourself talked about prepubescence, right? Like, that, the thing is, age correlates with prepubescence. Oh, that's right, I remember what it is. It's that it's not, when you're talking about mental capacity, one of the things which aids mental capacity is your sex education, for example, right? So one of the reasons you would draw the line at 18 is that the vast majority of the population has undergone their schooling system by the age they're 18, and so that they've already received the state deemed appropriate level of sex education. So you have like a guarantee on the mental capacity, whereas younger than that, you don't.
There's an overall focus that I'm trying to get across here, and maybe I'm just not getting there yet, but what I'm trying to say is that this should not be dependent on a number. It should be dependent on a person, which is how I view any sexual activity. If you are simply using someone for their body, you are abusing them. That's a problem. And maybe that doesn't necessarily need a legal issue. The only time it would need a legal issue is if an older person is specifically trying to abuse someone who is younger, who does not have the mental capacity to be able to consent. Hey, your visual's back. That's cool. But anyway, the point of my case is that we should be focused entirely on the individual's capacity to consent, which is based on their mental status. It is based on whether or not they are mentally able to do this. Now, you mentioned Hugh Hefner, and the Playboy guy, and how that would be a problem. Now, the only time when I am saying that there would be a problem is if someone is grooming another person who is not mentally able to consent. If a person is mentally able to consent, or is already over the age of 25, which is the age of full mental maturity, like Hugh Hefner's wife, that is acceptable. We're talking about those who might be mentally under the age, which should be dependent not by an arbitrary number, but by the mental capacity and by the individual circumstances of each case. Now, the overall point of your perspective is simply that it's easier to prove in a court of law if you just have an arbitrary, like a number. Now, this is true, and I think that's okay. And in fact, I would agree with that it's actually probably better to have a certain aspect of that be determined by age. That's why that's actually part of the things that I mentioned. If someone is younger, they already, juveniles are already held to a different standard. They're tried in juvenile court, and I think that's perfectly acceptable in this issue as well. If there is a juvenile who is being groomed, then the question is, has that been happening? If there's evidence of that, then we defend that juvenile. That's the point. It is simply a question of the intellectual maturity of each of the individuals. If one of them has the capacity to consent, they should be allowed to do that, unless the other one has been abusing them and manipulating them to the point where that happens.
Okay, juveniles aren't held to different standards. Juvenile court is when the person who is the crime committer is a juvenile, and they do it in that way to protect their identity, but they still have to prove beyond reasonable doubt. So that's just a misunderstanding of that aspect of the law. Look, here's what I reckon, and I think this is where we've kind of crossed past each other. In theory, if there was like a consent scanner, right, and I could just scan a couple and it would just come up with, was it consensual or was it not? Then I agree with you. But we don't have that. The way you would have to test the thing you were talking about is in a court of law. So do you, like, I'll pass the mic back very quickly because I think this will helpfully clarify. Do you admit that the ways in which this will actually be tested in real life, even though in theory, right, the age is just the number, is correct? I could agree with you that age is not a perfect number all the time, but because the practical ways we actually have of testing the age of consent is extremely problematic, i.e. forces 15-year-olds to prove in a court of law that they are abused beyond reasonable doubt, that the practical implications could be a reason not to do that, even though in principle, it might sometimes be okay?
To a certain extent, yes. You have two things that you said there. I'm going to quickly respond to both of them. You said juvenile court is different. I agree. Juvenile court is different there because it's about the perpetrator themselves. But the reason I mentioned juvenile court is simply to say that you can legitimately hold minors to a different legal standard because of their status. And I do think that is perfectly acceptable in these laws. I'm not making a specific law right here. I'm not a policymaker. I'm saying the general principle should be that it should be based on a case-by-case basis in which you defend the individual's right against being groomed. But you still also defend their right to be able to choose who they wish to have as a partner. As long as they are able to intellectually choose that for themselves, they should have that right. The other thing you were talking about was the court of law. And yes, I agree that in a court of law, it is often easier to have, that is where it would ultimately come out. That is the overall focus of this. And so, yes, I agree with that. And yet, the difference between the two of us is you're saying it has to be entirely based on the number 18. I'm saying don't make it be based on the number 18. Make it be based on the overall characteristics, which includes the number 18. It could include that. And it also includes who provoked the actual meeting between the two. It includes how much the difference between the two of them is. And it includes the mental status of the person themselves. All of these should be characteristics that are included in the court case.
Okay, you haven't actually answered the question though. And the question is this. At the moment, the reason 18 is a very good thing to have as just the test is that any 15-year-old's parent can go to a court of law and prove beyond reasonable doubt that it was non-consensual because it was under 18. They don't have to make any legal arguments. They just give them their birth certificate, right? That's very easy to do. Any poor person, any kid can present a birth certificate and a judge can be like, yeah, shit, they're under 18. That's abuse, right? When you include all of the other standards, right? Like, oh, your mental capacity, who initiated it, all of this other stuff, that involves legal argumentation. That involves a 15-year-old, right? A 15-year-old having to make a legal argument in a court of law or being able to properly communicate with their lawyer and getting cross-examined by another person, right? Like by the other person's lawyer. Like, I don't think you ought to put 15-year-olds in that position where they have to be cross-examined by another person's lawyer to test if they were of sound mental capacity or who initiated it properly. So it's not about whether in principle 18 is a perfect measure all the time. It's given the flawed measuring tools we have, do we think that we ought to force 15-year-olds into that position where they are going to have to be cross-examined by in some cases, their abuser, right, as to whether they were in sound mental capacity? Do you think that's a fair thing to put on those people?
Yes. We already have people who go on trial after being raped, and they do say, this was happening to me. That's the way it is. If someone is being abused, that's when we use the court cases. We do not use the courts if someone is not being abused. Here's where we actually should be able to agree. I think that you actually agree with me in that 18 is an arbitrary number. It is not an accurate number biologically. And so you talked about how right now the advantage of the current system is that we can go into a court of law and the judge can say, all right, you're under 18, boom, that's it. That was how you had phrased that. The problem with that is that that's not accurate. Someone who's under age 18 can and often does make consensual, mature decisions. They're able to. So it's completely inaccurate. And you yourself, you said 18 is not the right number. I think that a 16 is a better number, even though it shouldn't be based entirely on numbers. But it's not. So to have a judge throw out cases just because of a number that is wrong is an abuse of both the person and the accused. That's a bad way of doing this. It should be based on the individual cases themselves. And I think that you actually agreed with that when you said that you'd agree that 18 is not the correct number. And yet you still advocate that judges should be able to just throw things out because of age 18. That is abusive. Oh, wait, you know what? Before I put that away, you also were talking about 15-year-olds, and it's unfair to put 15-year-olds on the stand. No, it's not. Because the focus of this is that people should be able to make choices for themselves unless there is a problem happening, which is the same standard we have with any other legal issue. If someone is being abused, they go on the stand and they defend themselves. They say, this is what was happening, and then they go up there. It is the same standard here. If children see a crime or are part of a crime, that is already the standard. We will hold the same exact standards on that. The focus is simply on allowing those who have the capacity to make decisions to be able to make those decisions.
Okay, really quick question, because I've spotted a contradiction. Earlier on, you said juvenile ought to be held to a different standard. That's why we have things like juvenile court. But now you're saying, no, they actually ought to be held to the same standard. They have to testify like everyone else. So are you going back on the other thing, or what am I missing?
The same standard that juveniles are already held to. Okay.
The standard juveniles are already held to is that we protect them from the thing which you want to obligate them to do, right? The reason we have things like juvenile court and the reason which, for example, the way in which we interrogate juveniles is different is that we recognize that it's unfair to put someone who hasn't even finished fucking high school, right, to force them to make legal arguments, right? So that's why you have things like Dolly Incapax, for example, the idea that if you're too young, you're just incapable of committing a crime. And it's a very high standard for the state to prosecute anyone who's in that range. So at some moments in your case, you're saying, no, juveniles ought to be held to a different standards, but at other moments you're saying, actually, they ought to be held to the same standards. It's quite contradictory. The reason which 18, and by the way, in Australia, it's 16. Like if it was any number in that range, I'd be happy to advocate for it. But I'm just saying that a number is better than no number, right? And it's not arbitrary, right? It's not, if it was arbitrary, it would be anywhere between 100 and 0, right? Like it is, for one, correlated with pubescence fairly well, as in there aren't any 18-year-olds who aren't prepubescent. It is also correlated with what I pointed to earlier, the fact that they have gone through sex education because they've finished high school in the vast majority of cases. It is also correlated with ensuring parent confidence because it strongly deters anyone from going for that person in the first place. So it actually prevents the relationships happening in the first instance. And it's not like I'm restricting their liberties in any terribly abusive way, right? They can just wait a year or two, you know, like that's not that bad, right? And but the benefit I get, right, is that under your side, there are a lot of people who don't have them, and you haven't answered these questions properly, who can't afford a lawyer, right, who haven't even finished high school, who now have to prove beyond reasonable doubt, like, you know, that they were abused. The state ought to protect these people for the same reasons, and to bring in the analogies which you said different, right? The same reason which we don't allow them to enlist in the army, the same reason which we don't allow them to, to like consume materials online, the same reason we don't allow them to work in various occupations, or in some cases, if they're young enough, work at all, right? Because we recognize that when these are hazardous things, right? That allowing people to participate in hazardous occupations also gets coupled with the responsibility to actually be able to defend oneself in a court of law when those things go wrong. It is unfair to put that responsibility on people who haven't even finished high school and couldn't afford a lawyer and don't have the legal knowledge yet to do so. And that is why they ought to be protected until such a time which they are allowed to do those things, which is why you need a number to protect them from having the huge burden of proof, which is beyond reasonable doubt.
All right, so you talked about how there's a correlation with prepubescence. I agree. It's a general correlation, but it's not a specific correlation. One of them is it's a general idea. And that's why even in my case, what I talked about was how we can have a general overview. We're focusing on the individual case-by-case analysis, which can include age. Two of the factors that I talked about, the difference in age between the two and the age of the lesser person, should both be included. But more than that, they should also include the questions of who is initiating the contact and the ability of the person in the first place to consent. It is simply about looking at more than that. See, I think this is the difference between the two of us. You are focused entirely on a practical, oh yeah, well, it's just easier this way, it's easier. I am focused on the actual principle of the issue. And I think that's really where the difference between the two of us comes in. I see your case, and I understand that practically it is often easier to be able to defend a case if you can simply say the number is 16, the number is 18, boom, that's it. I get that. But at the same time, there are many people who that hurts, including the 16-year-olds. There are many 16-year-olds who are mature enough to make such decisions for themselves and do make such decisions for themselves, and you are preventing them from having that ability. I am simply saying that they should be able to have that ability, and if it appears that they are being abused, that's when we step in. You also talk about how the legal standard should focus on defending the juveniles. Let's just agree on that. All right, we can just agree on that factor. The legal standard should be the presumption for the juvenile. That's how for the most part, that's how we already do it. I'll just say that we'll do that from this point forward. You pointed out that there were contradictions on when exactly I focus on that standard. The focus is simply on the individual case by case. That's why occasionally it will be different. But the focus should be to protect people against being groomed while still enabling them to make decisions for themselves. So there's two countering goals, and we want to be able to balance both of them. You're only getting one of them. I'm trying to get both of them. The last thing you talked about, you said I hadn't answered this sufficiently, was that some of them can't afford a lawyer, so we need to give them an easier standard to be able to go with. But once again, that simply is coming down to the practicality. Your case is entirely focused on the practicality. Mine is focused on the principle. It doesn't matter if they can't. It's about the actual circumstances themselves. If the circumstances say that a person is able to consent, they should be able to consent.
Okay, so you're right to say that there's a principle-practical divide here. But the counter principle for me is protecting those who don't have the capacity yet to protect themselves. So there are two counter principles here, and it's a trade-off, right? It's what do you prioritize? What I'm suggesting is that you should probably prioritize practicals over principles a lot of the time, right? So for example, this is obviously a thought experiment, but if you had a principle about war, for example, but the practical implication is that nuclear war is inevitable, you wouldn't go with the principle if the practical was that everyone dies, right? So for example, in this case, you wouldn't go with this principle if the result is that 15-year-olds systemically get abused and raped and are unable to prove in the court of law that and get their abusers punished, right? You wouldn't go with this principle if it caused a mass uptick in abusive relationships. So I would say that the practical cost of implementing your principle is intolerable, and it is a reason which we shouldn't do it. But okay, let's move on to a few of the things you are concerned with, though. You said, look, the harm here is that I'm preventing these 16-year-olds from having sex. Listen, mate, this is the law right now. 16-year-olds, they're having sex, right? that it's not actually preventing these people from having sex in a meaningful way. What it is allowing them to do is that when they do get abused, it's very easy for them to prove so in a court of law if they're a juvenile. It puts, as you put it, the presumption of innocence on the juvenile. Now, when you said, listen, I'm okay to put the presumption for the juvenile with my system. You can't do that. That is my system, right? The system, the status quo is the presumption is with the juvenile. So your attempt to kind of meet in the middle is just going back to what we've got right now. Because, like, for example, if this is going to be the only criminal court case where beyond reasonable doubt is not the standard, then what is the standard? Balance of probabilities? This is going to be done in civil court? Like, and how exactly is a judge supposed to adjudicate this, right? Like, the presumption is with the juvenile, but it's kind of not. They've got to prove these standards. It's unclear to what degree they've got to prove them. Like that's a big problem, right? That is unprecedented in our legal system, and I don't know how anyone would judge that. At the end of the day, the sorts of standards you're talking about, the sorts of standards you're trying to introduce are subjective standards. They're designed to be more specific for the cases which fall outside the norm. What I'm suggesting is that those subjective standards come with costs, and the costs are that you force people who the state already protects from, for example, working rights, protects from many other things because we haven't educated them yet. We haven't given them the right to their own income yet. We wouldn't even allow them to get welfare by themselves independent of their parents yet. You're forcing those people to take on a responsibility which in no other venue would we allow them to. That is unfair. They do not have the capacity. The state has often made it illegal for them to have the capacity, so it shouldn't force it upon them in this instance. It should be protect them, and they can still have sex with their other 16-year-old friends, and it's not like anyone's going to call the cops on them. But when they are abused, they are protected in that they do not have to prove beyond reasonable doubt.
All right, let's talk about what we agree on. I think both of us agree that age is insufficient, and yet I think we both agree that age is often a very good practical way of defending kids. We also agree that presumption should be given to the youth or to those who believe they are being abused. And I believe that that is perfectly acceptable. You said that I can't say that, but I think that it seems perfectly acceptable that you would give the presumption to the one bringing the case. That is not a hard factor to incorporate into what I was saying. Where we disagree is that I think that there should be more standards that actually go into the issue as well. You're saying it should only be a number. However, we both agree that that number is insufficient. I'm saying that we should add more to that in order to be able to determine on a case-by-case basis. You point out that that is subjective. There are parts of that are subjective, but there are also objective standards within that. For instance, the difference in age between the two. If a 17-year-old has sex with a 25-year-old, that is apparently illegal. But then the next year, 18 and 26 is apparently legal. You have objective standards. It should be determined by the individual capacity, not just by a number.
Okay, but just because one of your standards is objective doesn't mean that the other ones aren't. And it's weird for you to say, look, I mean, the number's imperfect, but the age difference number, that one is perfect, right? After 10 years, 9 years, it's okay. 11 years, not okay. So in principle, you should be against an age difference standards as well. Otherwise, the case eats itself, right? At the end of the day, as long as you've got some subjective standards in there, which is a requirement if you want to be that specific, then you do meet all of the practical implications of a flawed legal system. Now, one of the things I want to hone in on one thing you said, which is that, look, it seems fair to me that I can say that the presumption will be of the victim. That is guilty until proven innocent, right? That means that the one who is now engaging in the consensual sex who's older or whatever now has to prove that they are guilty in the eyes of the law until they prove beyond a reasonable doubt that the other person was consenting. That's ludicrous. It's completely there is no other legal standard which does this, right? That is why it's so hard to send people to jail. So what that means though, right? What that means is that you're not actually enabling any liberties, because why would I risk having sex with someone who is, according to your standard, not even 18, 19, 20, if just because they're younger than me, I'm fucking guilty in the court of law. I have to prove beyond reasonable doubt my innocence. So the implications of your model practically is that you actually discourage even more people from engaging in otherwise consensual relationships, even if they're both under 18. So if you want to maximize liberty by introducing this presumption on the victim, you have actually quashed everyone's liberty, not on paper. It's a chilling effect, you know, kind of like the whole free speech. Oh, we're not going to send you to jail. We'll just, you know, make you lose your job and everything, right? So you've actually restricted liberty for people who would otherwise be perfectly okay to have sex under the status quo. But like, just to bring up again some of the things which I don't think you touched, obviously time restrictions and stuff, but one of the reasons age is really good is because it allows parents like the confidence to send their kids to public institutions, which we would all be deem valuable. Because if they feel like they have to prove beyond reasonable doubt, right, like in the court of law, that their child was objectively and subjectively unable to consent, you know, when they were 17 against the wealthy lawyer of someone else, then they're not going to send their kids to school. They're not going to send their kids to psychologists. They don't send them to school for many other reasons. And that is bad for the kids, for you know, overall. Why not just wait a couple of years and